Good morning, everyone. This is Jennifer Clark. I'm the Operations Coordinator with the New York State Coalition Against Domestic Violence. And today I would like to welcome you to today's webinar on the 2021 Legislative Session Review. Our presenter for today is the Director of Public Policy and Advocacy, Joan Gerhardt. Before I hand things over to Joan to get started, I'm going to go over just a few housekeeping items. If you would like, please feel free to introduce yourself in the chat box today. We are going to keep all participants muted. And you can find a link in the chat box to a copy of today's presentation slides, as well as to a copy of our 2021 Legislative Session Review document. We are recording today's webinar, and a copy of that recording will be sent to you in a follow-up email along with all materials that are associated with today's webinar. For today, we do also have live captioning available. To turn on live captioning, you can go into your settings and just hit the CC button or view live transcript. And with that, I will hand things over to Joan Gerhardt.
Thank you, Jennifer, and welcome to everyone. Good morning. And Jennifer, a special thanks for helping with the registration, as well as helping me facilitate the chat box, which is over here. So if people see me turning my head, I'm not ignoring anyone. It's just I'm looking at the chat box. So welcome to our annual review of the legislative session, which ran from January to June. We've got a lot to cover today, so unfortunately, I don't think we'll have much opportunity for dialogue on any individual piece of legislation. However, I will reserve time at the end for some questions, and we can always continue to discuss these new laws or any thoughts, questions you have at a separate time. Just send me a quick email or give me a phone call, and I'm happy to talk about these laws in greater detail. So with that, let's get going. You know, this was an interesting session this year, certainly compared to last year, still dealing with the impacts of COVID. All activities with respect to the legislature and the governor's office were remote. So there was no advocacy in the halls of the Capitol or in the legislative office building, but we were still able to do quite a bit of work remotely. And actually, I think the accessibility to legislators and legislative staff was a little bit better than in the past without the pressure of people coming in and out of offices. Legislators weren't traveling to Albany routinely. I mean, some did, but it freed up, I think, a lot of their time to meet with folks, and we definitely took advantage of that. With respect to the work of the legislature, they did return to the level of activity that we saw in 2019. There were just shy of 900 bills that were approved in both the Assembly and Senate together. You know, many other bills passed one chamber, but there were about 900 that passed in both chambers. And those bills are now going on to the governor. He has signed several, just under half. So we expect to see his activity on the remaining bills by the end of the year. So typically when we do our legislative wrap up, I do review what was in the in the budget that was approved for April 1st. And much of this you've probably already seen or heard about, but I do think it's important to include in our wrap up. So I'm going to run through this pretty quickly. We know that there was a lot of federal pandemic aid, which was in our state budget and earmarked for different purposes. One particular pot of funding that we were really pleased to see was about $20 or $30 million that is earmarked specifically for financial assistance to survivors for housing and moving costs, anything associated with relocation. So that money was in the OTDA budget. We're still waiting to hear some specifics about how that funding will be distributed, and we will, let you all know as soon as we hear. There was the $4.5 million of Enough is Enough funding, which is the campus sexual assault prevention funding that has typically been under the purview of DOH. And that funding did not change in terms of its level, but it did shift to the OPDV category. And now OPDV is going to be supervising those grants and grantees. Typically, we see $66 million of Title 20 funding in the OCFS budget for, they put it in a category of domestic violence and adult protective services, but this is the funding that is used for per diem reimbursements for clients who either did not apply for TANF or who are not eligible for TANF. So that money stayed the same, $66 million. And we also saw the same amount of money set aside for civil and criminal legal services for some vulnerable populations, including domestic violence survivors. So this was funding that was not included in the governor's executive budget, which is proposed in January. So we worked very hard with the legislature to get that money restored, and we were successful in that. So very pleased about that. Last year's budget included $5 million for a pilot project for OCFS to conduct to look at alternative means for funding domestic violence programs. And I think you all know that the per diem issue has been a priority for NISCADIV for several years. We've had many meetings and discussions, conversations, visioning exercises about New York's pretty antiquated system for funding domestic violence programs. And the state responded to what they were hearing from us by creating this pilot. So that was very good news. We expected the pilot to be implemented in 2020. Of course, the pandemic made that impossible. So we fully anticipate OCFS to conduct that pilot soon. But what we saw in this year's budget was an additional $5 million to conduct that pilot. So we now have a total of $10 million within the OCFS budget for this pilot. So that's really great news. And we hope to collaborate with OCFS on the implementation of the pilot, along with advocates. We also prioritize the funding that's available for non-residential domestic violence services. And for 21 years, pretty much with some fluctuation, the state has set aside $3 million of TANF funding for non-residential services. And we know that that's just completely inadequate. I mean, if it was adequate in the year 2000, when it was first set, then it's certainly no longer adequate 21 years later. We were hoping that we could double the set aside to $6 million. Many of you helped us advocate for that. Unfortunately, we weren't able to get that, but we did see a slight bump of $200,000. So we're now at 3.2 million. Some other important items, we had 2.45 billion set aside for emergency rental assistance. This is for the ERAP program that many of you might be assisting clients with emergency rental assistance. We know the state has been pretty slow in getting this money out to tenants and landlords. I think by the last account I saw, it was about 9 million has made it out the door, which is really nothing compared to 2.45 billion. So we're hoping the state can really get going with moving more of that money out the door. There was $100 million set aside for emergency shelter for undocumented low-income individuals, as well as $2.5 million set aside to improve the legal representation for low-income individuals in family court. Again, still need some details on how that money is going to be rolled out specifically, and as soon as we know that, we'll let you know. In response to some of the hate crimes that we've seen targeting Asian Americans, the governor and legislature set aside $10 million for not-for-profit organizations working within those communities to try to tamp down on the hate, frankly. And I wanted to make everyone particularly aware, as a reminder, back in 2018, the state changed the amount of time rape kit evidence had to be stored. So it had been 30 days, and then this new law in 2018 extended that to 20 years. So that's a vast difference. So within that new law, there was a plan for the state to develop, a long-term storage plan to find a facility to store all of these evidence kits and to maintain them and make them available to victims as needed. But there was no funding behind it at the time. And although the state was supposed to notify hospitals in April of this year where to send the kits, that never happened. There never was a plan, or maybe there was internally to the state, but never one that was released publicly. In this year's budget, we did see a very important allocation to fund this new storage facility. So the appropriation is $4.3 million. We don't know where the facility is. I believe there is a location in mind, but the funding is supposed to cover the planning for that facility, as well as transportation of the evidence kits to the storage facility. So we are working very closely with our sister coalition, Ms. Casa, to work with the state on this plan. We have a meeting with OVS coming up in the next couple of weeks to begin our collaboration. So we're very excited about that. So there are a few policy initiatives contained in the budget. Typically, the governor puts a lot of policy in the budget. It's his way of moving legislative initiatives forward. This year, most of those policy initiatives got stripped out of the budget, but there were a few things that made it through to the final approved budget. First, we had 3 extensions of particular provisions in statute that were set to expire or sunset in September of this year. And these are provisions that get renewed pretty much every 2 years. Last year, because of the pandemic, they were only extended for another year, but now we're back to a 2-year cycle. So these relate to the mandatory arrest law, the ability of vulnerable children to testify in court by closed circuit TV, as well as setting maximum lengths for criminal orders of protection. And that would be the 8 years for felony convictions, 5 years for misdemeanors, and 2 years for violations or other offenses. So all of these 3 provisions have been extended now through September 2023. There was a very important proposal in this year's budget to modify OPDV's enabling statute. Every state agency has enabling statute, which describes the responsibilities and roles of that state agency. So some of the proposal did make it through to the final budget, and other parts of the proposal did not. So what we saw approved was the shift of the Enough is Enough funding from DOH to OPDV, as I mentioned earlier, as well as the ability for OPDV to administer federal funds. So to officially become a funder to other entities outside of state government with federal dollars, as well as gifts or donations. What we didn't see approved was the name change for OPDV to include gender-based violence, as well as a shift of all of the programming and policy initiatives related to sexual assault, sexual violence. So that doesn't mean OPDV can't do that work. It just means that the enabling statute doesn't require them to do it. There were other policy initiatives, like I said, we were very focused on that were not approved in the final budget. This included a proposal to create a misdemeanor crime of domestic violence for the sole purpose of getting more offenders' names entered into the federal FBI database for future gun purchases. While we support that objective, we don't think creating a domestic violence misdemeanor crime is the way to go about that. So we communicated those concerns to the state, and that policy was not approved. 2 policies that we were supportive of, but did not make it through to the end budget, was one to include housing and moving costs within orders of protection, and one to take a look specifically at the issuance of orders of protection during the pretrial court proceeding stage collected by OCA and DCJS. So I don't think there was any opposition to either of those proposals, but I think they got stripped out of the budget as a number of other policy initiatives did. So before we move on to actual legislation, I just want to make sure there's nothing in the chat, Jennifer, that I should be responding to. I don't think so.
No questions in the chat box I've seen come through yet.
Okay, and feel free to add any questions or feedback as I go through. I know I'm moving quickly, trying to stay slow for our captioners, so I hope they're doing okay. But now let's turn to some specific legislation that these next group of initiatives that I'm going to discuss have already been signed by the governor into law. So they might not be effective yet, but they will be if they're not already. And there's no better place to start than the new law that aligns state statute with federal VAWA provisions for confidentiality. So these are the same confidentiality protections that rape crisis counselors already have when they talk to their clients. We now have in state statute those same provisions, those same protections enumerated. Now, this doesn't mean there's any change to the discussions that we have with clients. Frankly, we've already been operating under the federal confidentiality provisions. But the reason why we thought it was so important to embody these protections in our state law is because now it doesn't matter what happens federally. And what we saw with the last administration in particular, there was a rollback of many protections for victims in federal provisions. So now we're protected at the state level, no matter what happens federally. That's why this law was so important. But I want to stress, because I have gotten some questions about this, as have other NISCATIV staff. There's no training requirement associated with this new law. Certainly new employees at domestic violence programs should be trained on confidentiality, but that training will not change because our day-to-day work under this new law is not changing. We already have been operating under confidentiality provisions under VAWA, and this is just an extension within state law of those same protections. So no new training, no new certification for programs. The protections are for the individual working at a program. And the program has to be a licensed program. It could be a residential or non-residential. And the person has to be working under the supervision and direction of that program and have to be up on all of their existing training requirements that are dictated in the OCFS regs. So no new training, but employees or volunteers have to be up on whatever training requirements are needed, and then this privilege extends to them. The other point I wanted to make about this new law is, as you know, domestic violence advocates are mandatory reporters for child abuse or maltreatment. This law does not change that. So in conversation with clients, if there's information revealing suspected child abuse or maltreatment, domestic violence advocates must still report those conversations. So those conversations are carved out from the new law as not privileged. And this is effective immediately. So again, it shouldn't change anything in our day-to-day work, but the state law is now effective. So one other point I wanted to make on this, we've been talking to OCFS about this new law and whether there is any new guidance that's needed for domestic violence advocates or for other systems partners. It would be great if courts understood that our conversations with clients were confidential. It would certainly help us, push back on some, information requests to support litigation. We do think that there could be some modification in those template documents that we send back when we get requests for information. So NISCATIV is going to be looking at those documents and revising them based on the new law, as well as continuing to collaborate with OCFS on any additional guidance that should happen not only for advocates, but also for systems partners. So if anyone has thoughts on that, what would be most helpful to you in your work, please let us know, because that would be helpful as we craft an approach with OCFS. Another new law that we advocated very heavily on, many of you helped us do that on our virtual day of action, was a law to increase the age of consent to marry in New York State. So a couple of years, there was a new law that had the age of consent at 18, but did include a caveat that some 17-year-olds could marry if they had parental consent as well as consent of the court. So this new law now repeals the ability of 17-year-olds to get married. You have to be 18 in all cases. And of course, we thought that was critical, understanding that 17-year-olds cannot sign contracts in New York State, cannot file court proceedings, including filing for divorce. So we don't think anyone should get married if they can't file for a divorce. So we are very happy that the governor signed this into law. It is effective later this month. And I want to point out that as of August 22nd, any marriage licenses issued beyond that date would require the parties to be 18. But there is a grandfathering aspect to the effectiveness date. So if anyone currently has a marriage license, but has not actually solemnized the marriage, then they would still have to have both parties be 18. So I just wanted to clarify that. Quick mention, we had a law passed last year requiring the state to collect data about the homeless population, whether they were in shelter or on the street. This included domestic violence shelters, as well as all other kinds of shelters in New York. The intention of the law was to collect enough data so that if we had another public health crisis, the state would be better positioned to support the homeless during that time. When the governor signed the law last year, he did so with a memo of approval, which is his opportunity to weigh in on something that he's either signing or vetoing. And in this memo of approval, he raised a concern about the confidentiality of the information that was being collected, particularly from domestic violence shelters and runaway youth shelters. So this is a chapter amendment. It amends the law from last year and essentially requires the state to aggregate any of the information collected from domestic violence shelters or those youth shelters. So the confidentiality of any individual's information is kept privileged. So this is effective immediately. An important new law I wanted to bring to everyone's attention is a law that restricts courts from garnishing any of the pandemic relief funds that an individual has received. So garnishment happens when a court orders an employer to withhold a specific portion of funding from someone's paycheck and send it directly to a creditor or a person that the individual owes money to. And this is typically used for payment of child custody or for consumer debt or even paying student loans. So now if an individual received federal stimulus relief funds, the court is restricted from garnishing that money. But there's a few important exceptions for when the court can continue to garnish those payments. And this is why I wanted to raise this, because domestic violence survivors and family members might be included in this group of exceptions. So if there's a claim for garnishment brought by a spouse or a dependent, then the court can still order garnishment. In situations involving fraud, any action brought in family court regarding child support or spousal support, if the garnishment is ordered under an order of protection, or if it's a result of a civil or matrimonial claim. So those are very important exceptions. So the court cannot garnish pandemic relief unless the situation matches one of these carve-outs. And this is effective immediately. You likely recall over the past couple of years, we've had some real horrendous situations where coaches or medical personnel have abused victims in the name of medical examinations. And whether due to the age of the victims, the naivete, not having pelvic exams in the past, whatever it might be, victims weren't aware that what the coaches or medical professional was doing was inappropriate. So New York State has now passed a new law requiring DOH to prepare an informational brochure on pelvic exams. What's appropriate? What's the proper procedure? What should I expect in terms of privacy? And what sanitary expectations should I have? You know, should the doctor be wearing gloves, for example? Should there be someone else in the room? And the pamphlet, very importantly, will also include contact information should someone want to report misconduct with respect to performance of a pelvic exam. So these brochures are going to be available in several different languages. They're going to be available for download on DOH's website, as well as provided to medical providers for distribution to patients. And the brochures are intended to be ready for distribution by July of next year. You may have heard about this next law in the press. It was labeled the Gender Recognition Act. Very important, comprehensive new law. It actually does two different things. First, it permits the use of an X for an individual to designate their sex as non-binary on state documents, including driver's licenses. So that's really important. You wouldn't have to say male, female. You now have an alternative to that designation. But more importantly, I think, is that the new law says that there's no third-party notice that has to happen if an individual is interested in changing their sex designation. And there's no consent needed by a third party if an individual wants to change that sex designation. So no parents are involved here, no third parties. It's completely up to an individual whether they want to change their sex designation on state documents. It's their own volition. The law also sets forth a new process, a simplified process for changing this designation, as well as for changing a name on a birth certificate. And here's where I think this is particularly important for domestic violence survivors. We know it's been very difficult to change birth certificates in the past. Whether someone thinks it's the right decision to do that or not, we now have a simpler process for making that change. And most important, the state has removed the requirement that an individual seeking a name change publish their current name and their new name, as well as their address in the local newspaper, which we know is a definite barrier for many people to apply to change their name. The law also expands eligibility for keeping these records sealed. So all of the application materials relevant to either changing a sex designation or a name change can now be kept confidential, not publicly released, if there's a consideration for the applicant's risk of violence or risk of discrimination. So a very good change there. And this is all effective as of the end of the year, December 24th. I see someone in the chat, Karen, mentioned that that they've updated their HIPAA release to include an X. That's a great change. Thank you for mentioning that. And I think we might have another question. Am I going to discuss the AG's report at all today? I wasn't intending to, but let's see if we have time to do that at the questions later. Thank you, Randy, for that question. Another new law is one that was labeled the Walking While Trans law. And this repeals the prohibition against loitering for the purposes of prostitution. This was enacted back in the 70s as a way to combat, the proliferation of prostitution. But the law was really vague, and the way it was implemented by law enforcement seemed to be quite arbitrary. Trans individuals, women who have been repeatedly arrested for prostitution, Black and brown individuals were for the most part charged with this crime. So this repeals the crime from the books, effective immediately. No one can be arrested for loitering at this point any further. We're starting to see quite a bit of focus on the criminal justice system, as you know, with bail reform and discovery, but really through all the stages of incarceration and parole, probation, and even re-entry into communities. One of the reforms that has been signed into law this year was called the HALT Solitary Confinement Act, and that does exactly what it suggests. It limits the time someone can spend in solitary to 15 days. So, we can debate. I mean, I would think no solitary makes sense in my personal opinion, but this at least limits it to 15 days. Incarcerated individuals cannot be in segregated confinement for months at a time. It also reduces the types of infractions that would make an incarcerated individual eligible to be in solitary confinement. And importantly, it exempts vulnerable populations from ever being in solitary confinement. So the young, the elderly, individuals who are pregnant, individuals with disabilities cannot be put in solitary. And this becomes effective in March. The one thing I want to add about this is there is some activity in New York City on solitary confinement. The New York City Mayor, de Blasio, made a commitment last year to completely ban the use of solitary in any correctional facilities in New York City. Their Department of Corrections, so this is limited to New York City now, just issued a plan in June to implement this ban. There's been some criticism and concern of the way the plan envisions banning solitary, because there is a new proposal to still allow incarcerated individuals to be contained within their cell for 23 hours a day, with 1 hour in sort of like a lockout cage, I think is the term that they use in the plan, which would be connected to their cell, but would allow some fresh air and would enable one incarcerated individual to have contact with a neighboring incarcerated individual. So some legislators have signed on to a letter to New York City to say this does not meet the intention of either the restriction on solitary confinement or the mayor's commitment to ban solitary confinement. So we'll have to see how this all plays out, and we'll continue to keep you apprised. So I wanted to run through a couple of additional laws, actually more than a couple, in a quicker fashion to make sure you were aware of them. I don't think they need a lot of discussion, but of course we can always come back if anyone has questions about these. There's a new law to allow DOCS, the Department of Corrections and Community Supervision, to communicate with victims about incarcerated individuals via email at the victim's request. So no longer by snail mail, which is a huge improvement. And this would relate to, if the individual is released from prison or if they escape, which is actually detailed in the law. So if they escape, the victim should be able to hear about it via email. There's a new law to create multidisciplinary teams to address very complex cases of elder abuse. And these teams would include medical professionals, mental health, financial advisors, a whole gamut of individuals who could weigh in and provide expertise on the next steps pertaining to elder abuse cases. The Interagency Task Force on Human Trafficking has been extended for 2 years. The task force was set to expire as of September of this year, but they will continue their work for another 2 years. And the legislature and governor also approved an extension of the time period that a victim of human trafficking has to file a civil claim. So currently, or before this new law, it was 10 years, and now victims have 15 years from the date that they were freed from their victimization. And I would like to make you aware of a caveat that the statute of limitations here is told if the victim is a minor or if the victim has disabilities. So for those two circumstances, then even the 15-year time period can be extended. The state moved to ensure that part-time employees, in addition to full-time employees, can receive unemployment benefits. Definitely something we should be looking at for our clients. And the legislature also extended the ability of referees in family court to determine applications for orders of protection. So that was extended for another 2 years as well. And if there's anyone who has feedback on that process of these referees weighing in on orders of protection, I'd really like to get some information about that. It's not something I know much about. So if that's working or if it's challenging, I'd really like to understand that process better. Excuse me. Two important changes with respect to the interviews that applicants have when applying for public benefits. Now the DSS, at their inclination, can have these interviews by phone. And a second law allows the applicant to request the interview to be by phone or by digital means if they want. So a request on either side for a virtual interview. The state moved to establish veterans treatment courts in places outside of New York City. This is something we were watching very closely and doing a lot of work to advocate on because we were concerned that family offense cases might not be best served in a veterans treatment court. And the state heard us on this, and actually the final law carves out any family offense charge that involves a household or family member, that would preclude that court proceeding from moving to a veterans treatment court. So it would stay in the initial court of jurisdiction. I would be remiss if I didn't include the legalization of recreational marijuana on our list. I know you probably all know quite a bit about it. It was covered quite widely in the press. But it's important here because I think from our social equity work to understand our mass incarceration impacts on communities, marginalized communities across the state, and how the state is moving in a direction to change that. I was impressed and relieved that the ultimate law included provisions to move 40% of the revenues from marijuana sales to the communities most impacted by the war on drugs, and the expungement of criminal records for individuals who were charged on crimes that under this new law would no longer be illegal. So two very important aspects of the final law. And there's another law, this is sort of a minor one, but I think important from an educational standpoint, to eliminate the term incorrigible in PINS proceedings. These are the people in need of supervision. And we know that, that the term incorrigible was applied really inequitably, mostly to young women of color, to signify that in the court's mind, they were just so reprehensible that they could not be, what's the word I'm looking for? Thinking of the word, but they couldn't be restored. They were just so far gone. And it's very, very distasteful. So we are now prohibiting the use of incorrigible going forward. So we're going to move now to a number of bills that have passed both chambers that we're waiting for the governor to take action on. But before I do, I just want to break and see if there's any additional questions in the chat that I should be addressing. Jennifer, can you help me with that?
Yes, we do have one additional question asking, when does the Department of Social Services phone interview law take effect?
I'm just scrolling back here. I can look that up. I believe both are effective immediately, but I will definitely check on that. I can check on that and get back to you. Okay, so let's continue then. So that's it, Jennifer?
Yes, that's the only question. There is also a comment that someone made about their family court referee that they have in their local program is helping with orders of protection, and they're seeing hardly any of them being denied when the referee is helping.
Great.
Really.
That's great feedback. Thank you. Thank you for that. So now let's move on to, so these are bills that passed both the Assembly and Senate. They're identical bills. So they are moving on to the governor for his either approval or veto. The first ends cyber sextortion. Some of you might recall that back in 2019, we had approved our revenge porn legislation, which criminalized the intent to distribute intimate images if someone, one of the parties in the pictures, had a reasonable expectation of privacy, that those images wouldn't be shared. This cyber sextortion essentially is the next stage of thinking on the sharing of intimate images. This involves if someone threatens to release the images in a way to coerce someone to, perform some illegality or some other inappropriate behavior. So this would expand the crime of coercion in the third degree to include the threats of publication of intimate images. We have had an accommodation for domestic violence survivors with respect to election registration records. Survivors can ask Board of Elections to keep those records confidential from public release. But in order to get that accommodation, it required a court order. So the survivor would have to go to court, which is a huge barrier, we understand. This bill would actually permit the individual to self-attest to their status as a domestic violence victim. And just a word here on that self-attestation. We saw for the first time last year in the state's Paid and Family Sick Leave Act, this ability for domestic violence survivors to self-attest to their status. This is a huge win for survivors. No longer do they need to go get a third-party attestation from an advocate, a healthcare professional, an attorney, to document, to support an application for an accommodation. Now the survivor is empowered to self-attest to their victimization. So we're going through, NISCATIV is in the process of going through state statute to find all of the accommodations currently available to domestic violence survivors that require a third-party attestation. And we're working to change that third-party attestation to a self-attestation based on the Paid Family Leave Act, excuse me. So this is the first bill that actually does that, that got approved in both chambers relating to the election registration materials of a survivor. Now, it does require the survivor to renew their application every 4 years. I was hoping that we didn't have to require a repeat in any time frame, but the legislature saw fit to include that, but it does permit that self-attestation. We also have a bill to mandate that all shelters provide free feminine hygiene products to residents in shelter. And this certainly applies to domestic violence shelters. We did some dialoguing with advocates across the state to see if this mandate would be particularly onerous. What we heard was most facilities are already providing these materials, these products to residents free of charge, usually either by volunteer donations or other grants. It doesn't seem to be an onerous requirement. Of course, we're always careful when the state sets a mandate for domestic violence programs without funding behind it. So we're watching this one very closely. If anyone does have concerns about this requirement, please let me know, because we are continuing to communicate with the governor's office about this one before he takes action. We have been focusing much more on the circumstances of incarcerated individuals, not just survivors, but everyone who's incarcerated. And we are thrilled that one of the bills we worked pretty hard on passed both chambers, which is to support an incarcerated individual, to permit an incarcerated individual who is pregnant to have a support individual with them, whether it's a family member or a friend, as they're in labor and childbirth. So we think this is, a huge improvement for women behind bars who are giving birth. It also does require docs to provide information to pregnant incarcerated individuals about pregnancy counseling, as well as the right to an abortion. We have a bill to expand the definition of elder abuse to include identity theft. And there's also a pretty comprehensive bill I wanted to bring to your attention, which is referred to as the Consumer Credit Fairness Act, which is not targeted specifically to domestic violence survivors, but I think could assist many of them with respect to some of the debt collection lawsuits that they might get dragged into because of their partner's debt collection debt practices, or obtaining debt in their partner's names. So this law provides certain protections to consumers from abusive debt collection practices. And this really applies to these outfits that go and buy very large portfolios of old third-party debt, defaulted debt, expired debt. These are things I don't really understand, but apparently many of these lawsuits are filed without consumers even knowing that they are a party to a lawsuit. So one of the things that this law does is make sure that every party to a lawsuit is noticed and also understands what their ability is to counter a lawsuit. We know that many consumers don't have access to legal services to help them challenge some of these behaviors, these practices by bad actors, frankly, on debt collection. So this really tries to strengthen the consumer rights with respect to these abusive practices. And there's also an important bill that relates to recipients of public assistance, or TANF. And I think you're probably well familiar with some of the work and interview requirements, maybe educational requirements of for recipients of public assistance. Of course, we have our waiver for domestic violence survivors for some of those requirements. But essentially what this bill does is reorients the work of DSS, who for recipients of public assistance who become non-compliant with these work requirements or other areas of requirement within TANF. So instead of sanctioning recipients, for missing a meeting, which consistently happens, now the DSS, instead of viewing it in a punitive way, will focus on how to get an individual re-entered into the workforce, get them the skills they need. So not from a punitive standpoint, but from almost like a counseling or mentoring standpoint. Now we'll have to see how DSSs actually go about implementing this, should it be signed into law by the governor. Maybe we'll be able to collaborate with the state on working with individuals on reentry or re-energizing them into the workforce. But I think it is certainly a move in the right direction, rather than a punitive response, to have more of a positive support response. We also have some bills related to threats of immigration. So we're expanding coercion to include threats related to someone's undocumented status. We have a bill to enable domestic violence survivors to break utility contracts that are bundled with other family members or partners, just like they do with phone contracts and cable. Now, I just want to point out that this bill had not been modified to allow the self-attestation that I talked about earlier. So if the governor does sign this into law, we will be working next year to amend it to a self-attestation standpoint. And an interesting bill to have the court consider the best interests of pets in divorce proceedings. New York State treats pets as private property. So when family members separate from a household, the issue of who gets to keep the dog is a very difficult one. And frankly, the dog is not really permitted to leave the property, leave the household. So this would focus the court on what's in the best interest of the animal rather than who owns the animal. So we're watching that one very closely because we think that could be a benefit for domestic violence survivors. We're waiting on some action on human trafficking laws, or bills. There's a bill to exempt sex trafficking victims from having to be included in the DNA database because these people are victims, they are not criminals. Many of you have been watching the START Act, which would vacate convictions of trafficked individuals. Back in 2010, New York State took the step to vacate prostitution convictions of trafficked victims, but this would include any charge that someone's convicted on if it relates to their victimization. And we have another bill to require prosecutors and DAs to inform victims of their legal resources, of available legal resources, as well as counseling resources. So all focused on human trafficking there. And I did want to mention that we're waiting for the governor to sign the Housing Our Neighbors with Dignity Act, which is focused on converting distressed hotels in New York City into affordable housing. So I believe that there was an appropriation in the budget of $100 million to do this. Of course, that's not nearly enough, but it does show the state's commitment to focus on affordable housing. So I'm going to do a look ahead for next year. I'm being watchful of the time, but Jennifer, just another quick check on the chat. Anything I should focus on or talk about?
No new questions, just a reminder that there is a link to access the materials, including the presentation slides, in the chat box for everyone. And a copy of that will be sent to you along with the recording link after this webinar.
Great, thank you, Jennifer. So just looking ahead for 2022, what NISCATIV is going to be focused on, and of course this evolves and changes. We still have 6 months through the end of the year, or 5 months, to really kind of flesh this out. But what's on my radar is certainly the per diem issue. NISCATIV has been prioritizing this for a long time, and we continue to beat the drum on this issue. We've got the OCFS pilot that we know is going to be conducted. We know that the state, with OPDV's leadership, is working on consolidating a funding application for all of those federal funding streams that you apply for, FIPSA money, VAWA. I don't know what's going to be involved in this. So hopefully it's going to be comprehensive and will reduce all of the onerous reporting and, applying for these funds that we do on an annual basis. As well as we know the state is actively engaged in looking at funding models of other states to see what we can learn and best practice. You all know that NISCATIV has been doing this research for years. I think the first study that I'm aware of that NISCATIV undertook was done in 2015. We did an additional study in 2019, just before the pandemic. We've been visioning with all of you on DV funding, and we're continuing to provide all of that information to the state so that it can, help the state move in a direction of modernizing the funding model for New York. We're going to be keeping tabs on the implementation of criminal justice reforms that were done in 2019 and 2020. We've had a couple of listening sessions with all of you to talk about bail reform and discovery. Those discussions will continue, as will an assessment of new laws pertaining to weapons search and seizure. We know that OCA is doing a round of county by county educational and awareness discussions to ensure courts understand the new laws, and we'll be watching the implementation of them. And we're also going to be continuing our work on the requirement for applicants of VOCA compensation to coordinate with law enforcement. This has had a long history. You know that it was required as part of the 1984 VOCA Act that applicants share information with law enforcement. It was kept deliberately vague in the federal provisions for the states to be able to define for themselves what coordination looked like. And of course, here in New York State, we require applicants to file a police report, which is not just coordination. I mean, that's a heavy lift. And we know for some victims, that's an insurmountable challenge. They don't want to go to the police. They don't want to coordinate in any respect. So we did see some movement throughout the pandemic with the governor suspending the requirement that applicants for VOCA get police reports. We're definitely working to make that a permanent change. We have heard from OVS, who is the administrator of VOCA funds, that it would be impossible to make any changes to our protocol unless we change the statute. So regardless of what happens federally, New York still has to change the statutory requirement with respect to filing a police report. So we're looking at that very closely along with other stakeholders and expect to be working on that a lot next year. We have our family court work. There's the Blue Ribbon Commission on Child Custody Evaluators that we're participating in, best interests of a child, supervised visitation. I'm trying to run through this quick because I know I only have a few minutes left. Certainly judicial training as well as training of all court personnel is on our radar. We also, from a prevention standpoint, continue to advocate on our Healthy Relationships K through 12 curriculum, also called the sex ed curriculum. We are working with the state on offender accountability programming. OPDV just had a couple of public hearings at which NISCATIV testified, as did several others. And we expect to be working closely with them on whatever results of that work happen. We will continue our focus on criminalized survivors and taking a very close look at the implementation of the Domestic Violence Survivor Justice Act, supporting both incarcerated individuals on resentencing applications, as well as criminalized survivors who are just going through their initial court proceedings to support them under the new law, as well as looking at all of the parole reforms that are being talked about. So whether we want to support efforts to permit parole at age 55 or discretionary release for individuals, we're going to be hearing many, many more initiatives focused on reforming the parole system. I did want to put out for you, we do have our dates for next year's lobby days. So mark your calendars. We're definitely hoping that these are in person. Budget Advocacy Day on February 15th, as well as our Legislative Day of Action on April 26th. And I know we only have a couple of minutes left, but I did want to see if there were any further questions or anything that someone would like me to get back to them on. Please just, add it in the chat. I will put here is my email. Feel free to reach out to me. It's really the best way to get to me. I'm pretty responsive, and we can have a conversation, or if you're interested in receiving any of the actual texts of these bills or laws, happy to send them to you and talk further. So Jen, anything coming up in the chat, or we'll certainly stay on for a few minutes to see if there's anything that comes up.
I'm not seeing any new questions, but please feel free to put it in. Joan, did you want to talk anything about speak about
the governors?
Yes.
See how I forget? NISCATIV did issue a fairly brief statement on social media, which, I can circulate around to everyone. Obviously, this is very disturbing. We thought the allegations themselves initially were disturbing. We believe the victims. We never doubted that what they said was true. And now we have the AG's report, and I have not been through it yet. I was preparing for today's webinar, so I didn't have time to actually go through the report thoroughly, but I plan to do that today. But I think it's disturbing, and I think that anyone who conducts themselves in this manner in the workplace should be held accountable, and it doesn't matter what your position is. So I think that's the view of everyone at NISCATIV, and we'll share our statement to all of you so you can see it. I want to thank everyone for being here. Like I said, we'll stay on, and have a great rest of your day.